now return to Mind Your Own Business on Dzrj810 AM, the voice of the Philippines. Here are your hosts, Nicole Jacinto and Nikki De Vega.
Welcome back to the program, folks. I'm Nicole Jacinto. Nikki De Vega is not with us today, but we have attorney Jennifer Lizano, whom Nikki De Vega sent in her place. She has sent her. Anyway, Nikki, if you're listening right now and watching while you're abroad, don't forget, Nikki, you can, if you're not tuning in via facebook.com/DZRJ810am, you can also tune in via Ustream. That's www.ustream.tv/channel/DZRJ-810-am. But of course, you know that already, Nikki. I'm also saying, I want to say hello to Nikki, who's abroad, and to all the other people who are listening in the California area, in Las Vegas. Hello to the friends in Las Vegas, and to the friends and some family in New York City. Good evening to you guys. Anyway, Attorney Lizano is with us here today. And Nikki, you should know that they miss you, as we do. We all miss you. But anyway, if you want to call in, folks, and ask questions or share your experiences with us or just make comments, call us at 897-8374, 895-4460. And again, you can text us at RJAM, that's all caps, space, type your message and send it to 2256. Now, Attorney Lizano, let's pick up where we left off. You said, that pretrial and mediation are actually part of the trial process. So, yes. I want to stress to the listeners out there that when you get into business, especially when your business is growing, sometimes you really can't avoid going to trial because of business issues, things that come up, and even in our own lives. Like, in this show, we want to help people figure out how to mind their own business, in the sense that, your own business could be what you do with your personal assets, things that have to do with inheritance, personal property. And it can really get all muddled up if you don't have a clear vision or the right information. But I'm glad that you prepared and for today this topic of pretrial and mediation. Now, you said earlier that pretrial and mediation has actually helped declog the courts, the dockets, as you put it, because everyone has the impression that, oh my God, it will take 10 years for that case to be resolved, and often that is the case.
That's what actually happens.
But let me ask you, just in a very general manner, how has it helped? And maybe you can answer that by explaining pretrial to us first before we go to talking about mediation.
Okay. The pre-trial stage actually happens after the parties have filed their respective pleadings in court. The court will set the case for pre-trial conference. Now, the pre-trial conference is required to be attended by both parties. It's actually mandatory that they participate in the pre-trial conference because this is the stage where the court considers several matters which will govern the general direction that the trial proper will take.
Okay, so so the pretrial takes place before the judge. You were saying earlier that it's conducted before the judge.
Yes.
Okay, and then you just said that the parties have to attend the pretrial.
Yes.
The pretrial
conference.
Okay, I was thinking of the word. What did you say? Conference. Okay, that's held before the judge. This is important because, as you were saying, it determines the direction. You also said earlier, off the air when we were talking, that the things that are not discussed during pre-trial will not be admitted during trial proper.
It will not be allowed in trial proper. Basically, because during the pre-trial, the parties are ordered to simplify the issues that will be submitted to the court for resolution. Like, for example, if Corporation A sued Corporation B for breach of contract, the issues that should be resolved by the court will be simplified into, for example, one single issue, which is whether or not Corporation B has committed a breach of the contract.
So that it's faster.
Yes.
And also, like, when sometimes when you watch TV, like, you all of a sudden you see shows about people in court and stuff. You can't just pull in things like, and you stole my cell phone. That's not part of it.
That's actually objectionable.
Okay, so when you see people like coming in, suddenly there's a witness. That witness was not on the list. There are exceptions that are made, or overruled.
That's actually the kind of situations that the pretrial process seeks to address, because during the pre-trial, both parties are ordered by the court to submit a list of the documentary evidences that they will be presenting, and then any further evidence that are not included in the list will not be allowed by the court.
But in your experience and to your knowledge, let's say something comes up and it's relevant and it's close enough, can you put it in during trial?
Yes, provided that during the pre-trial conference, your counsel has made a reservation of your right to present further evidence.
So it's very important what happens in pre-trial.
Yes.
And even before that, let me stress here that what I'm getting is that it's very important to really speak to your lawyers very well, your counsel very well, and tell them everything that you want.
Litigants should be vigilant enough that they shouldn't just trust everything to their lawyers. They should attend the pre-trial conference.
And you should also be like before. For example, I go to you. I have a case. I should tell you everything that I possibly can think of and want to bring up, and then you will help me filter out.
Yes.
Like you'll say, okay, that one is not really that relevant. Let's not talk about it, or they might not. Maybe we should pay more attention to this.
Yes.
You know, so that's also the job of the lawyer.
Yes, and the lawyer will also tell you what's missing, what needs to be further included in the list,
what can be explored.
Yes.
Now I have a question about, you said the parties have to be present at pre-trial. Let's say, you know, it's because when cases are filed, let's say the case is filed somewhere, it's not convenient or not practical for the party to be there at the time or go there all the time. Is there such a thing as special power of attorney that you can grant your lawyer to represent you?
Yes, actually that is the main practice that the courts require the lawyers to present during the pretrial conference. If a party is not able to be present, first he should have a justifiable reason for his absence, and then second is that there should be a special power of attorney given to the lawyer or the representative, and such special power of attorney must specifically state that the lawyer is, or the representative is given authority to enter into amicable settlement,
and
or
to act on the behalf of the litigant or the party.
Make admissions.
Make admissions. When you say make admissions, that means admitting evidence into court or papers into court?
Not necessarily. It means admissions of facts, factual allegations. Okay. Yes, because the parties, during pretrial conference, the parties are also required to enter into a stipulation of facts.
So you have to kind of like, sort of, it's like saying you're swearing that
these things are true, and when certain facts are included in the stipulation of facts, then these things will not anymore be proven during the trial. So it actually,
so it's kind of like in those old black and white movies, we see people raising their hand and swearing on the Bible. Do you swear that to tell the whole truth and nothing but
no, not really, not like
that.
that.
It's not like that. It's just like, it's understood that these are facts that you want admitted into the record of your pretrial documentation and conference.
It's called a pretrial order.
A pretrial order. Okay.
For example, in our hypothetical case earlier on, if Corporation A sued Corporation B for breach of contract, then the stipulation of facts will probably include that both parties are admitting the legality of the existence of both corporations. And then the contract. Yes.
You're right. They both have to admit, if party A sues party B and they go to court and it gets to the point where there's a pre-trial conference already, which is already part of trial, as you said. So both corporations are admitting that they exist as corporations and as legal entities or as a juridical entity, right? And then they also have to admit that they had a contract, and one is saying that they breached it, and the other is saying that they did not. Something like that. Or
so
they had,
at least the existence of the parties and the due execution of the contract is already admitted, so they don't have to go through all the process of procuring all the documents from the Securities and Exchange Commission to prove the legality of the existence of the corporation.
Yeah, because that would take longer,
like
and then you could be objecting on all grounds, and
that will actually take at least 2 years.
So this really helps, the pre-trial thing. But I have to stress here, really, you know, that you should really get the lawyer for you. Know your lawyer. Make sure your lawyer knows you, and make sure that they are looking out for your best interests. And that special power of attorney you can grant, that's actually a common practice that is granted to the lawyer.
For parties like corporations or business entities, what is required is that they should issue a board resolution authorizing their counsel to attend the pre-trial conference on their behalf.
Okay, and then what happens when they show up at trial? It will be, because of course the corporation is they're made up of a bunch of people. Will it just be like they assign one person to represent the corporation?
Yes, they
at trial?
usually assign a representative. It's usually the president, or if it concerns employees, it's the HR manager.
Okay, and then you were stated earlier that they have to have a justifiable reason for not appearing at pretrial. Give us a couple of examples of a justifiable reason.
Well, for example, health reasons, or for example,
economic.
Parties out of the country, or is a resident abroad.
Okay, yes, and then is it valid? Let's say, economic reasons, like the venue is far away and you can only afford the transportation for your lawyer, which is more important for the lawyer to be there than the than the actual litigant or party at that time, because the party won't know what to do because they're not. Is that a justifiable reason?
Yes.
Okay, so actually there are a lot of reasons that are justifiable, and
courts are actually lenient when it comes to reasons, as long as there's an SPA.
Okay, as long as there's an SPA, that's very important. Okay, so that in that sense, as you put it very simply, I can see how, and I'm sure some people out there can see how, when they talk about pre-trial conferences, how important it is and how much it declogs the courts.
Yeah.
Okay. We actually have to pause for a short break, but I want to stress again, when we get back, we'll talk about mediation, and then we'll just go through some of the things you mentioned earlier, like very quickly, like pre-trial, and we'll just say again what it is, its importance, the legal consequences of the failure to appear. Let's talk about that. And then a few other things, like what the heck is court annexed meditation? Some of us have never, mediation. Some of us have never heard about that, but we'll go to mediation after the short break. And again, I want to stress how important it is to have the right lawyer and someone who you have chemistry with, who knows looking out for your best interest, and who's also knowledgeable. And later I'm gonna ask again for you to read out your numbers, because I really believe in your law firm. So anyway, we're just gonna take a short break, and if you wanna join the discussion, don't hesitate to call 897-8374, 895-4460. We'll be right back. Stay tuned to Mind Your Own Business right here on DZRJ 810 AM, the voice of the